This panel is compliance session, 1 to fight versus 1 to settle an enforcement action. The moderator is Renato Mariotti, is a partner at Thompson Coburn and former federal prosecutor who handled the first ever spoofing case and other high profile enforcement matters. Thank you very much for being here.
Thank you. I'd like to introduce a very impressive panel that we have here, and I'm going to go from farthest away from me to closest to me. So at the very end of the table, we have Rob Howell, who is Chief Trial Attorney at the CFTC here in Chicago, and is handled all sorts of high-profile cases, but most importantly, the Kraft case, which you've heard a lot about. So we will definitely draw on his expertise and try to put him on the spot as much as we can, get him to reveal things about the Commission's thinking. Then we have Matt Kluchenik next to him here in the center. He's a partner at Baker McKenzie. Matt is not only somebody who had been at the CME in the past in market regulation, but also has had a long career working enforcement cases from the other side, and is also, in addition, an expert on cryptocurrencies. Is going to be on that panel, handling that panel as well. And then, of course, we have Seth Travis, who's General Counsel of Tezek Technologies, a hedge fund and previously a trading firm. I met Seth when I was in the government, and Tezek let the government know sort of famously about some of the information that led to the Cassia case. And so he will give us an in-house perspective on some of these enforcement issues. We're going to go through a number of different cases, and you can feel free to ask questions at any point, but I will try to leave time at the end for a question or two. So let's start. I'm going to start now, as a starting point, to throw out a question to Rob. Rob, last month, the CFTC issued an order settling spoofing charges against the Bank of Tokyo, and at the same time went out of its way to issue statements about the benefits of self-reporting and cooperation. So can you explain for everybody here the benefits of self-reporting and cooperation with the Commission?
Sure, and first I got to give the disclosure that you've all heard before, that these are my personal views and don't reflect the views of the CFTC or the commissioners or the division or anybody else for that matter. But I think Bank of Tokyo and the order's interesting. It's a fairly short order, and for those of you, it was an administrative file and settle, and it was a $600,000 CMP for a spoofing case that had gone on for a few years. I think the order says it was like 5 years, but most of the conduct was within 2 years. I think what's of note is that the order reflects what's been going on at the CFTC, which is a move to formalize our cooperation and self-reporting options. There was some guidance in January that was put out about cooperation that lists sort of, I think tried to give some clarity of what is cooperation. I think for a long time at the CFTC it was a little bit of an amorphous concept. And so in the Bank of Tokyo order, our director, Jamie McDonald, specifically said that one of the reason that the Bank of Tokyo had the fine, which was fairly low, and I think we're going to contrast it with some other cases going forward, was specifically because the bank, when it learned of the conduct, suspended the trader. It reported it to the CFTC, so the CFTC learned of the conduct from the company. They cooperated fully with the investigation, and then they did, it sounds like they did substantial remediation of their systems and controls to make sure, and training to make sure that they would catch these things in the future. Our director, Jamie McDonald, this has been a real point of emphasis for him, that our self-reporting and cooperation, that we need to bring transparency to it, and that there's a distinction. So the message that the CFTC is trying to get out is that there are going to be meaningful incentives for self-reporting and cooperation. And to get the most credit, there's sort of 3 prongs. There's self-reporting, cooperation, and remediation. Self-reporting has to be prior to an imminent threat of disclosure or an investigation. It has to be made reasonably promptly after a company becomes aware of the issue. and the company has to reveal the facts that it knows at the time. And then there's also, so you can have self-reporting, but then there's also cooperation. And the goal here, I think, and what we're really trying to do is make sure that when a company does self-report, that they understand sort of what the expectations are for them to fully cooperate and receive the substantial credit. On the flip side, when a company comes to self-report, that they are entitled to have some transparency and certainty about what they can expect from the division. And so I think the hope with this program is, to have to bring less cases and to get information about conduct that the division normally wouldn't learn about, and then also to reach the most culpable persons. That's pretty much the general goal.
Let me ask you a follow-up, if you're able to answer it for us, Rob. I know I used to be on your side, so I know it's sometimes hard to answer things when you're in the government. But I'm curious, how important is self-reporting? Because I think a lot of folks in the room, if the CFTC knocked on their door, or more appropriately sent them something over email, they would certainly cooperate and respond. But self-reporting requires somebody to be proactive and invest money in surveillance. So how important is that to getting the sort of result that the Bank of Tokyo did?
Self-reporting is very important. And I think you'll hear more from the commission as this goes along. But to get the full credit, you have to have sort of the three prongs. You have to have self-report, cooperation, and remediation, if that's what is deemed necessary. You can still get credit if you just cooperate without the self-reporting, but it won't be to the same level that you would if you had sort of all three. And the idea is that if you do self-report and you do cooperate and remediate, that the credit will be significant. Sure.
Thank you. So as a follow-up to Renato's question, I can imagine a lot of circumstances where things happen internally at a firm. They have a robust surveillance and compliance program. They find out about a trader who's done something, let's say, engaged in a spoofing strategy. Despite their best efforts to prevent it up front, they find something after the fact. They discipline or fire the trader. They put in place additional surveillance. And they're trying to decide, is this something that rises to the level where I need to self-report it, both from the perspective of CFTC's interest and to get the credit. Can you flesh out a little bit what type of behavior and when it gets to the point where self-reporting is something that should be seriously considered?
So that one's a little bit tricky. I mean, it's facts and circumstances. Always. Yeah. I mean, we close cases all the time, so it's hard to say without knowing like a specific circumstances. Obviously, I would suggest you err on the side of self-reporting because certainly if it's minor conduct, or if you report something that maybe it's less of an issue for a particular entity, but we figure out it's an industry-wide issue, I think the division would be receptive to not prosecuting. But again, it's a tough one, not knowing what the facts and circumstances. But I don't think there shouldn't be a downside if it's a minor issue and it's something that the company is proactively. They're the ones who identified it. They've taken care of it. I would imagine the division would give a lot of credit for that.
Thank you.
One other kind of follow-up. I think that there is. In the industry, there's a feeling that if you don't self-report, if this is something that the commission brings to your attention, that sometimes cooperation will not result in a significant benefit. I mean, do you think that feeling or that perception is incorrect, Ron?
I've heard it and seen it in my dealings, and I think one of the reasons the CFTC is trying to do this is I think we're moving to get more in line with what the Department of Justice and the SEC has done. I think by, I don't want to say codifying, but formalizing this and at the outsets letting, having more transparency, so if you do self-report, this is what is going to be expected of you, and this is what you will get. I think the hope is that eliminates some of that. I think one of the issues is there have been in the past, cooperation, and there's a lot of different views on what cooperation is. And I think with our last director, Eitan sort of started this. That's why they put out the guidance in January about what it means to cooperate, because complying with a subpoena is not cooperation. And so I think the big thing on cooperation, the message is that in this program where you self-report and cooperate, is that you need to be proactive. It's not reactive. And there will be expectations. It depends, again, there may be an internal investigation. And so I think a lot will be expected, but the benefits have been, and I think there will be more messaging that they're significant.
And just to clarify for the audience, when you're talking about codifying benefits of cooperation, when I was in the U.S. Attorney's Office, there are very specific expectations and guidelines for what cooperation people receive, cooperation credit people receive when they make a deal with the government. So it's sort of, there's an expectation you get a recommendation of a third off your sentence, for example, if you cooperate against someone in the same case. So everyone sort of knows what you're potentially getting out of the deal up front. And if, to sort of expand on Rob's comments in a way that I don't know if he would be able to, if to the extent he's suggesting that CFTC is trying to do that, it could create more expectations so market participants know that, hey, I'm going to get X if I cooperate, which helps people like all the three of us who are trying to make decisions about whether to cooperate or not with an investigation. All right, well, as a bit of, I think, a foil to that case, I want to move to a case on the very much opposite of the spectrum and ask Matt as a starting point about that. Matt, there was a $25 million fine against Citigroup that was announced earlier this year for spoofing. It certainly captured my attention. I think it captured the attention of many other people in the industry. To the best that you could tell from the outside, what about that case justified the massive fine, and what can we learn from the non-prosecution agreements that the CFTC entered into with some of the Citigroup traders?
Sure. Thanks, Renato. So by way of background, Citigroup agreed to pay a $25 million fine, which was and remains the largest fine paid for a disruptive trading or in connection with a disruptive trading case. And then there were also settlements by two traders, sort of a mid-level Treasury futures trader and a more senior trader. And then you had three traders that entered into non-prosecution arrangements. So it was a very complex case involving, multiple parties, individuals at different levels within the organization. And I think for purposes of the Citigroup Global Capital Market settlement in particular, big focus on the commission was the expansiveness, allegedly, of the conduct that occurred. So you've got multiple individuals. They really seem to home in on a couple of factors that Rob frankly touched on, but one in particular was this whole notion that, so Citigroup in its procedures essentially said that this type of conduct would be subject to a self-reporting obligation. We've all heard the thing with respect to compliance manuals, careful what you put in there, because if you put something in there, then you have to follow it. And so with Citigroup, and the CFTC kind of sends a message, I think, in the order and sort of highlighting this. Citigroup had such a procedure, but didn't follow it. Of course, Citi was not required to self-report under the CFTC's rules or the Commodity Exchange Act, but it did have something in its procedures, and according to the CFTC, chose not to follow that procedure. So you almost really have a breach of a procedure, a compliance procedure, that the CFTC viewed as important. The other thing that was, I think, a big factor in that case was centered on training. So, training means a lot of different things, right? Training could mean sending around emails that, thou shalt not engage in disruptive trading practices. We've all seen those, and you could send one of those and you could send, a dozen of those. But is that really training? I think, if I could attempt to speak for the CFTC wants to see more robust, a more tailored form of training. So it's not just sending emails. It's not just putting, blanket language in a compliance manual saying that you can't do this. It's really a scenario-based training where you're sitting down with the traders, you're walking them through, particular scenarios. You're having a discussion about what constitutes disruptive trading and what doesn't. You're memorializing all that. You're doing it on a regular basis. That, frankly, doesn't happen at a lot of firms within this industry, certainly more so, now than a couple of years ago. But I think the CFTC's expectation is you can't just send around a bunch of paper. You've got to be more proactive. You've got to be more involved. And again, it's really got to be tailored. And so that's sort of a chief takeaway for compliance staff. So I think that was sort of, some of the larger considerations with respect to that fine. And what's really interesting about that case is, again, as some of you may know, you had a couple of settlements by two traders involving 6-month vacations, if you will, and fines of $200,000 and $350,000 CMPs. But you had 3 traders that entered into non-prosecution agreements. And while those types of agreements are not uncommon when dealing with the U.S. Attorney's Office or dealing even with the SEC, for the CFTC, the agency, by my count, had never done it before. So that was a new sort of take on addressing this. And in those, with respect to those traders, you had some factors. I wouldn't call them unique, but they're relatively uncommon. You had traders who early on in the process, very early on in the process, took responsibility for the action. And so you actually had, you had admissions by those traders. You had traders who were willing to cooperate with the CFTC staff. And again, all this is early on, not kind of after the fact, but early in the process, and ostensibly to aid staff in better understanding the allegations with respect to others, the industry, disruptive trading, and so forth. And so you kind of had again, relatively uncommon set of circumstances. And you also had junior traders, not traders who were significantly involved in the alleged conduct. They were more on the periphery, if you will. And so to the agency's credit, they sort of, broke out of a mold and said, okay, not only are we going to enter into NPAs with respect to these traders, but and Eitan issued this on the last day he was in office, issued really comprehensive guidance, which I don't know for a fact, but I suspect it came out of the sort of the NPA process with those individual traders, just given the timing. So, a number of interesting dynamics, but importantly, I think you take a moment, read the orders, even read the press releases, there's a lot of sort of hints, indications, calls to the industry, things to do, things to try to improve on.
Very much so. It struck me as a case in which the CFTC was trying to make a statement. And one of my takeaways, and I'm curious if your perspective is the same, is that it appeared to me that perhaps Citibank took a very aggressive position against the commission at some point in the process, and these individuals who got the non-prosecution agreements maybe were instrumental in getting that result for the CFTC. I wonder if you had...
I think the latter may be true, but I'm not sure I would agree with the former.
Okay.
I think that, there's sort of a play card, if you will, I think, in terms of how registrants approach investigations and so forth. And, I don't know that I'd say there were material deviations in that respect. Mm-hmm. I think that really the focus, you certainly agree with the latter comment, that there was responsibility early on by the traders.
So if there's somebody in the audience who's thinking, okay, wow, an NPA sounds fantastic, because to the extent that isn't completely spelled out for you, that means paying $0, having zero penalty, which is obviously a fantastic deal. What would be your advice to someone if they're like, could we qualify for an NPA? What sort of characteristics would somebody...
Sure, great question, and that's wrought with a lot of implications, right? Because the first thing you probably have to deal with is, am I prepared to make an admission of conduct? A lot of serious collateral implications with respect to admitting conduct, both publicly as well as, in respect if you're a trader, mortgage applications, whatever it may be, a lot of questions where you may actually have to acknowledge an admission to what is a fraud-based provision under the Commodity Exchange Act. So that's the first thing you have to grapple with. The other thing you have to grapple with, and I think we're still trying to feel this out, is what does cooperation mean? Does cooperation mean, sending off some emails where I provide some general thoughts? Does it mean, I go in, I meet with staff for 6 hours a day, and I, get into the nitty gritty? Not a fun process. Going to the dentist is probably more fun, and you do that over and over and over for several months. Is that what's required of cooperation? Does it mean, an agreement to actually testify? Basically, on call at the request by CFTC staff and testify against former colleagues. So those are all the things you want to try to scope out and negotiate. But suffice to say, a lot of potential implications of it.
It's my experience, and I'm curious, Matt, if it's yours as well, that the CFTC is at the point, at least now, where they are looking for, when they talk cooperation, they're looking for people who are going to testify, looking for people who are going to come in and walk through documents with them and tell them everything they know.
Yeah, no question about it. We all know that the CFTC, like a lot of agencies, is hampered by only so much in terms of resources, right? And there's a lot of alleged misconduct going on out there. So I think the value of meaningful cooperation is only going to continue to rise and be more meaningful. And the commission and commission staff in particular, frankly, more thankful, more grateful for a genuine, willingness to meaningfully cooperate.
I'm happy I don't have to make the resource statement.
Can I ask a follow-up?
Yeah,
There's a question out
anytime.
there.
Yeah, I'd love one.
Okay.
Yeah, real quick follow-up, if you don't mind. So looking at it from the in-house perspective, and firm hires you as outside counsel to come in and deal with a potential issue. You have individual traders in the company to think about. Can you speak to sort of where in the process and how you go about determining when there may be separate counsel brought in for the individuals involved as opposed to maybe your role on behalf of the company?
Sure. Good question. It's a question that comes up a lot now because the CFTC typically focuses not only on an organization, but individuals with these types of cases and other types of cases. So, different attorneys say different things. I think that if there's a consensus around one particular thing, is there a conflict or do I foresee a conflict between the organization and an individual? And so if there is a conflict, that's a clear-cut case, outside counsel. If you see, based upon sort of whether it's an internal investigation or otherwise, that things are kind of lining up, so there could be a conflict, then I think the better course of action is sooner rather than later, because you can't unring a bell, right, is to get separate counsel. The other thing is, personalities are involved here, right? And sometimes you have a really big, important trader who simply says, I want my own counsel. In that sort of scenario, most organizations would not insist that he or she share the same counsel as the organization. Right. So,
there was a question in the audience.
Oh, sure. I didn't see the question.
Did you have a question? Yeah.
Yeah, I think you were talking about the difficulty for government agencies with funding or whatever, right? So you would like to have this cooperation, but again, we see a lot of sometimes huge fines, right?
But those go to the Department of Treasury, so they don't go to the agencies that bring the action. So yeah, we read about the LIBOR fines and this and that for hundreds of millions of dollars. The CFTC doesn't see a penny of that. It goes all to the Department of Treasury. I'm sure they would like to change that, but.
And one of the goals, though, frankly, of this emphasis, and you're going to hear more messaging from the division on this, of the self-reporting and cooperation, I think it's to give transparency because it should incentivize individuals and companies to come forward. Because really, our goal is compliance and enforcement. And so if companies can do it themselves and remediate and come and bring the information, it allows us resource-wise to, focus on the most culpable actors, whether it's a particular individual or somebody higher up in the organization.
Before we move, sorry. Yeah. Oh, for sure. We're interested.
Sure. Yeah. I can, truthfully. And well, and again, you get into facts. So, I mean, based on what you said, I definitely could. Now, it's usually more gray than that. It's important. I mean, that's why some of the factors I talked about, self-reporting, it needs to be on your own. Oftentimes we'll get self-reporting when, the exchange has already reached out, or, a whistleblower, something's happened, and that's not, or we're about to start an investigation. So the self-reporting has to be genuine. I mean, if you detect it and you find it and bring it, for sure you will get credit for that. And I think, Jamie's goal in this is that when you come in, there's a discussion about, here's the expectations. You also have to reveal all the pertinent facts that you have at the time. And then there will be discussion about cooperation from there forward. How do you stay in this lane to get the maximum credit? But yeah, no, I in talking to Jamie, I'm confident that if a firm, had all the right systems in place, and you had a rogue trader and they caught it and suspended the guy and immediately came in, I believe that, yeah, there could be no action with respect to the company. But, maybe there is with the individual, and they need help with that. But
Just to follow up, if I can, on that, did you have a follow-up?
I just want to say before you get to your follow-up, we did get an answer from Rob, so I can.
Yeah.
Major kudos.
it's my answer, but
worth
yeah.
the price of admission. Okay, Matt.
One of the difficulties is when you go down the path of cooperation is typically, you don't get any feedback, and nothing is telegraphed. So you could be cooperating in you think, and genuinely, a really significant factor. And, while the staff wants to reserve, the division wants to reserve the right to do anything, it would be helpful as part of that process to get some feedback as to, what, we're heading in the right direction, We're on the same page. We like what you're saying, but just, as opposed to simply like no feedback, no comment about the extent of, potentially multi-year periods of cooperation. And it's tough to get that.
Yeah, if I could add to that, as you said, Renato, up front, at Tesla, we were involved in raising concerns that we saw that appeared to be spoofing to us that led to prosecutions later on, but that was several years after we raised the issues, and we heard nothing for a long time. Now, that wasn't with the CFTC, so I'm not commenting on anyone here specifically, but we didn't hear anything for a long time, and there's a fair amount of frustration from the people who are identifying those things. It's usually not me or the compliance staff directly that are going to raise those issues to us. It's going to be our traders, our technologists, our quants who see these issues and bring them to us. And if they need some measure of feedback or continued motivation to do that, and if you throw something out there and then don't hear anything for 3 years, it can be a little bit of a disincentive. So it's, I guess, a comment or encouragement to the regulator.
No, and I'd agree. And the flip side is hearing nothing for 3 years that's unfortunate. These things take time, especially like these spoofing cases we have to prove intent, and a lot of us are lawyers, and we talk about the resources. So some of these things can take a lot longer than certainly victims and whistleblowers and people would like. And and the former federal prosecutors here will tell you. I mean, the wheels of justice can move much slower than any of us want. And so that's certainly and that's incumbent on the teams, whether it's a CFTC or other, to make sure that they are communicating. But it is a one-way street too, which is difficult. We're not allowed to share a lot of information with people that have, say, brought a complaint. And so it can be, I deal with it all the time. Even, fraud victims that have been duped out of their retirement. It's frustrating because we can't give certain information to those folks.
What I would say too, I mean, just to sort of throw something Rob's way, I hear that in the industry, not just about the CFTC, but about multiple regulators and exchanges. It's a common issue is you notice something, you report it, you don't hear back for a while. And kind of on another point I want to hit before we move on, the Citigroup order, I think, got a lot of attention because $25 million captures everyone's attention. And I saw certainly there was a talk about insufficient training, and I've gotten a lot of requests for spoofing to conduct spoofing training since then. But there's another piece of it where there's the commission found that Citigroup did not have adequate systems and controls in place to detect spoofing by traders. And I'm curious if anyone on the panel has thoughts about what that looks like. In other words, Citigroup's a pretty big entity. You would think they'd have significant controls. How do you? What sort of expectation do we have of market participants in terms of detection?
I can start from the
that'd be great.
inside perspective, if you'd like. It's very difficult. I mean, there are certain things, and we'll get to other behaviors where I think supervision and surveillance is much more straightforward. On the spoofing side, I think it can be very, very challenging. The issue that I was talking about earlier, where we reported, came about because our traders saw behavior that was impacting their strategies. And they could go and dig in based on what they saw. Generally, when people are negatively impacted, they're motivated to look more deeply and could see a pattern of behavior of large trades getting posted, canceled, trading, and flip-flop back and forth. When we've tried to evaluate how to proactively monitor that on the spoofing side, it can be very, very difficult because you have a lot of false positives. There's a lot of very, very justifiable reasons to be posting and canceling transactions and then trading along the way. And unless you have a lot of information, a lot of nuanced view about what you're looking at, trying to pick that out in an automated way or even harder in a manual way, it can be extremely challenging. So, and I'll come to more of this when we get to the next case, but I think on the spoofing side, to me, it's more about information gathering. From a compliance and legal perspective, what we always try to do, and I should interject here, I'm speaking for Seth Travis. It's not a CFTC issue, but I'm not speaking on behalf of heads of the organization. But what I try to do is make sure that we understand before a strategy is rolled out, what's the intended behavior? What's the goal behind the strategy? You don't necessarily have an opportunity to dig into each of the alpha. That's probably beyond most of our expertise. But to understand generally what the trader is trying to get at and what they expect the behavior to be, so you can find ways to monitor that behavior. And if you see deviations from that, you can go back to the trader and understand more. Again, trying to measure exactly what is spoofing and what is not in a vacuum is very, very difficult. But having a lot of information sharing up front and along the way, I think is the best way to try to monitor that behavior.
Just to add to that point, so surveilling for certain types of spoofing is not all that difficult, and maybe I would say certain types of disruptive trading is not terribly difficult, but there are some types of disruptive trading where it's almost impossible to surveil on a daily basis. And there are third-party programs out there. We've all heard about these. Some work great. None of them cover the entire spectrum, especially when disruptive trading continues to sort of evolve from a regulatory perspective. The thing I do fear is with respect to that language, whether it's in this order or any other order, is sometimes that just becomes sort of a piggyback. I mean, if there's a violation, it seems like then, by definition, there were inadequate procedures or controls. And, I think more ultimately, through orders or otherwise, more guidance by staff in terms of, what was the particular insufficient control or procedure? Why was it? As opposed to these blanket statements to better guide the industry with respect to that. Because I get this question all the time, and, not just with respect to spoofing, but other types of violation. You see that phrase a lot. And people are like, well, what do I have to do?
I mean, the practical advice I can give, because people are looking, I think sometimes, well, okay, what do I do? Well, what do I do? I'm here to learn. And what I would say is, get one of those surveillance programs, even though they're not perfect.
It's a start. Yep.
It's a start. Have your training, keep those PowerPoints and sign-in sheets, and be able to have something to present to the commission, say, here's what we're doing, here's what we're trying to do. And like Seth is talking about, when traders have strategies and they're coming to you with questions, document those. I've had cases where I've had to prepare people to talk to CME Group Market Reg who are compliance officers because traders came to them about strategies or they approached traders about a false positive and then they didn't write down what happened in the conversation. It happened 2 years ago. So kind of documenting the guidance that you are giving the traders, I think is helpful as well. So I'm going to transition now because I think this really is a
question back here.
Oh, I'm sorry. I didn't see. Yeah. So let me, oh, sorry. I will tell you, I want to kind of answer your question in the first instance because back when I was even in the government investigating spoofing and then when I came out, I heard questions like yours for almost every panel I was at. I was at practically every spoofing panel for a period of time, either in the audience for a while when I was in the government watching and taking notes of what people were saying, or then later on the panels. And I'd hear that question asked, and sometimes I literally was on a panel with the head of enforcement, then head of enforcement with the CFTC, or with Steve Schwartz or Steve Schweitzer from CME Group, and they would hear that question. And they would always find a way of avoiding answering the question. That's my honest answer to you, as somebody who's not affiliated with any of those entities, is, for whatever reason, CME Group does not want to go that direction. They've heard a lot of input, and they're not going to go that way. And I don't know why that is. You could ask Steve Schweitzer yourself. I have heard people ask them, and their answer was not direct to me. But I just think it's a practical matter when my clients ask me that question, I have had clients ask me that question. I'm like, look, that's not the world we live in. That's not what they're going to do. And so we're left with this sort of open-ended rule, and that's what we have to live with. I don't know if you have anyone has a different perspective.
Yeah, and I should repeat here. I'm definitely speaking for Seth Travis, not for Tesla, but in my experience there, we've lived in the world where we've traded at lower frequencies and high volumes, and we've transitioned to worlds where we're trading with longer holding periods and lower volumes. So I've seen a lot of it, and I do think saying that there should be a minimum resting period tends to be an oversimplification. There are a large number of traders out there who are engaged in large amounts of volume and liquidity provision at the various markets, who manage their risk on extremely short-term time intervals. So the minute you say that those traders need to have a resting period that is larger than their usual time interval, you're going to have potentially a withdrawal of liquidity and volume from those markets. Now, I think I'm probably speaking the language of a high-frequency trader when I give that answer, but I've seen it, and so I think there is validity to it. The question certainly is how much is market impacting validity versus protecting someone's market opportunity? And I think that's certainly a difficult question to answer that a lot of people have different perspectives on. But I think you have to be careful anytime you put sort of a market impacting rule on there. And then, while you may look at an order and say, oh, I couldn't get that because someone else did, now there's a change and you look and the spreads are 2 or 3 times as wide, and you never even have a chance to see the order that if you built out your technology, maybe you could get that order the next time. So I think it's a difficult question to have a simple answer to.
There's a question right here.
Yeah.
What's kind of the handoff there from the SCM perspective? Where do we start? Because, like you said, sometimes you put something in and you don't hear about it for 3 years. So, how do we know that we're on the right track?
If I can. Great question. You really have 3 regulators, right? You got CME, you've got NFA, and you've got the CFTC. And I've had to deal with this question where who do you go to first? And we've actually seen these sort of regulators compete with one another in terms of, well, you have to bring your person in first. Over here, if you want sort of cooperation credit, as opposed to going to an SRO or whatever the case may be, or vice versa. So really delicate situation, but I think you've got a sort of lot of fact and circumstances here, but you got to be prepared to, around the same time, initiate discussions, I think, with all 3 regulators, or certainly 2. NFA might be a little bit different depending upon the nature of the violation, but certainly CME and the CFTC. You can't assume just because you self-report or go to the CME that's going to be sufficient with respect to the CFTC, and vice versa. You just can't make that assumption.
And one thing to piggyback on what Matt's saying, both kind of from a perspective when I was in government and now even seeing out, you can even see from public statements that the regulators make that they're not always on the same page. CFTC and CME, you see some disagreement. And I think going to both does have a advantage of, like he said, playing them off against each other. One thing that I've seen is when, let's say you're a market participant concerned about activity, like Seth was talking about earlier, where you're complaining about activity, one thing that has helped one of my clients is, they complained to the exchange, didn't get an answer. I went to CFTC and then got CFTC interested, which sort of forced the exchange to then be interested. So sometimes going to both can have some beneficial consequences. So we only have a couple minutes left. I'm going to very quickly kind of get to one more case that I'm going to have that I'm going to direct towards Seth. It's a case I was involved in, so I'm not going to say much about it. But there was a case, DV Trading, a case that generated a $5 million fine and involved 3 different wash trading strategies. I think the order indicated that compliance there did not detect or investigate those strategies. As General Counsel, what practical advice can you give us about detecting and investigating wash trading?
Thanks, Romeo. And I'll talk about this one, I think, primarily from the perspective of the question we got earlier. What can you do up front to try to stay ahead of this stuff so that if you do get a question from the CFTC, how can you demonstrate that you've been on top of this and that you've been a good actor the whole time? And when I see the order here, and in this case, as Renato said, it was a series of wash trading strategies that led to a $5 million fine, which from my perspective is a pretty massive fine for wash trading, and suggests to me there's a little bit more meat on the bones than perhaps we saw in the order, and at least the perception of an effort across the company to engage in these sorts of strategies. And certainly it's easy then for me to say, well, the first thing you should do is not have a policy of engaging in wash trading. So first and foremost, don't do that. But I would hope that that's certainly where everybody's starting, and you're trying to get to a deeper level than that. So I think about, again, how can we put policies and procedures in place that try to help protect us? And the first, and although it's obvious, is have procedures in place and follow them. Right? Make sure they're fleshed out. Make sure they explain what your policies are behind wash trading and what you're going to do about it, and then follow those. And then again, it's a simple point, but have good education. Make sure that everybody in your firm from top to bottom lives by the notion that we're going to follow these rules from the perspective of coming up with strategies, putting strategies into the market, and then monitoring them afterward. You have to live by that from the top of the company all the way through. And again, as part of that, as I mentioned earlier with regards to spoofing, understand what your traders are putting out there. What's the intent of the strategy? What markets are they going to be engaging in? Are they passive or active strategies? How much volume do they think they're going to be involved in? Under what circumstances might they be on each side of the market? So you can have a sense up front about whether they might match with themselves, which I think is a pretty significant problem, or whether they may match with other strategies across the firm, which is, I think, a slightly lesser problem. But again, depending on your policies, your procedures, your motivations, could also rise to the level of a very significant problem. So I think you want to do all those things up front, and it's got to be, it's a trite phrase, but you got to have a culture that allows this to permeate your entire firm so people understand that it's not going to be acceptable. Then on the back end, at least from my perspective, unlike spoofing, and we could probably talk for a while about how good some of those programs are, I think wash trading is a different animal. At least we've been able to have monitoring in place so that on a daily basis, we get reports that show what trades are self-match. And in our context, where we're fully automated, fully electronic, this is all unintentional. But you want to make sure you know where that's happening on an unintentional basis and understanding what your tolerances are for that, and try to figure out what those tolerances are. Again, that can be a challenging thing. If you call the CFTC, they're not likely to tell you, well, 2% is fine or 3% is fine. You have to ferret some of that out. And we have over the years had conversations with the CME, with ICE, to try to understand in different circumstances what's going to be tolerable, and that can change over time. And they, again, don't give you firm answers that you can just write in a book and say, here's our limit, but it gives you some understanding of their comfort level so that you can create your own policies and watch those strategies and watch the inadvertent matching that you have, so that when you see behavior, if it starts to tick up to the level that you think might be an issue, you can go to a trader and say, why is this happening? Why have we seen an increase? Is there just market volume that's increased that you didn't expect? Is it likely to dip back down? Did you make a change to your strategy? Is that what's driving it? And understand some of those behaviors. And then, depending on what you learn from all of that, the question to me is, what do you raise with the CME, or I suppose the CFTC, depending on the seriousness of it? You go to them and ask, what are they seeing with your strategies? Are they seeing self-matches? Is it anything that they think is problematic or disruptive to the market? And do you have those conversations directly where in-house legal counsel, your CCO is making that call? Or are you calling Renato and asking him to make that call on your behalf, or Matt, no disrespect intended, to make that call on your behalf so that you can get some feedback from the CME, again, to understand if you've got an issue that's a one-off, that's just part of your supervision and monitoring, or it's something that you've got to be more proactive about and maybe self-report because you've got a bigger issue. And so, as you're dealing with all of those things, it's a way of, again, developing a culture of compliance that I think is important. Another piece that I'll add, and then I'll turn it back over to you, Renato, is it's part of your ordinary compliance. I'm sure everybody does this, but if you have an issue, look at written communications, look at emails, look at your internal chats. Unfortunately, those places oftentimes have a repository of very, very troubling information. You want to let folks know, as part of your training, that those things are being reviewed. And if there's something that they would regret writing about when it's looked at with the benefit of hindsight, don't just not write it. Don't do the behavior. And I think that's got to be part of your training, part of the compliance culture that you have. So again, for me, it's all about setting up the right culture and the right processes throughout the entire life cycle of a strategy so that you're on top of this stuff and so you can be ahead of it before the CFTC has to come to you.
Unfortunately, our time is up. But can everyone join me in thanking this fantastic panel?